Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge. They don't know they missing. Got a couple current events that you like. Wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifted. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
I guess I should come on the screen, huh? Hey, everyone. Happy Thursday. It is Pam Esquire, also known as Your Law Intellect. If you are new here, welcome and consider hitting that subscribe button. And if you have been here before, welcome back. Thank you, KRS1, for being a member for 6 months. I appreciate the support. Hey, Ray. What's going on, you guys? I hope you guys are having a fantabulous day. Of course, we are here to talk about Diddy because, that's kind of what's going on right now. And so, no, I'm not talking about every little thing that comes out about Diddy, but just those things that kind of pique my interest. So, on my daily checking the dockets for Diddy, it was a very interesting filing that occurred in the Court of Appeals, of which I felt the need to go live and to discuss it, because I know there were some buzzing around that there may be another try for a bond, and I am not talking about the appeal, okay? Because right now we know Diddy went before a magistrate. The magistrate was like, "Yeah, no, bro, we are not letting you out," and then he went and he said, "I'm going to appeal it to the actual judge residing over the case," and that judge was like, "Shut that down real quick." So then Diddy waited a couple of minutes and hired an appellate attorney and went to the Court of Appeals. Now, some people were reporting, which was false, that he was denied on the Court of Appeals or the third time. That is not accurate. What happened was his attorney filed the appeal and then was requesting that her client rather, which is Diddy, be out on bond pending the appeal, because there's actually a hearing date now for November 4th. So there wasn't a denial of that actual appeal. It just was you're not going to sit out here while we decide what we're going to do on appeal. So that was false information that was floating around and some people asked about. So I just wanted to clarify. Well, we know that Diddy filed the appeal and filed the brief. And the government yesterday, they actually filed a response to that brief. And today, Diddy's a lawyer has said, hold on, time's out, hold on this appeal, and asked the court to wait, to hold it in abeyance, because they are going to try again in the trial court and do a renewed motion for bonds. So we are going to read that. Thank you so much, Name Change 412. Thank you for the super chat. I appreciate that. And we just early morning vibe said, what happened today? We're just staying up on it as things are filed. We are trying to be in the making sure you guys are in the know of the process and the procedures that is going on in this Sean Combs Diddy saga. So I don't expect we'll be here that long. However, before we get into the document, which is pretty brief, it's not like my 25-page long-winded lives that I have to do. This should be fairly brief. But when I tell you Diddy is the epitome of at first you don't succeed. If you were on my Instagram page when I posted that I was going to go live, that was the song that I put up there, because he's like, dust yourself off and try again. That is one thing that Diddy is going to do. If there is a will, there is a way. He is trying to get up out of jail so that he can discuss with his attorney and come up with the defense for these allegations that have been waged against him. Yes, be so kind and hit that like button on the way in. I appreciate that. Early we are here to try again. Absolutely. So let's go ahead and get into this without further ado. Usually I try to wait for a little bit more to come in, but you guys might have to just do the rewind, okay? So this is what was filed on today. All right. Motion to hold appeal in abeyance. Pursuant to Federal Rules of Appellate Procedures 27, appellant, because he is the one that brought this, so he is the appellant, and the United States, as you see, is the appellee. Sean Combs moves to hold this appeal in abeyance pending further motion practice in the district court. This is an appeal from the district court September 18, 2024 order denying pretrial release on conditions and ordering Mr. Combs detained pending trial. Mr. Combs filed his notice of appeal on September 30th, 2024, and filed a motion for bail in this court on October 8th, 2024. The government filed an opposition on October 18th. Well, that hasn't happened yet because today is the 17th, but they did it on the 16th. So that's a little typo. 2024, and Mr. Combs' reply is due October 23rd. This court scheduled oral arguments on the motion for November 4th, 2024. So those of you that didn't see, I believe it was yesterday, the court actually put on the docket that the oral argument will be on November 4th, 2024, arguing about the bond. So if you just came in, when people were saying he lost already in the Court of Appeals, that is not accurate. It has not been argued yet in front of the panel. So the 3-judge panel. On October 10th, 2024, a pretrial conference was held before the district court to address discovery, scheduling, and other issues in the case. At the conclusion of those proceedings, the district court indicated that, quote, if the defense has any bail application they would like to raise, then it will certainly hear it, end quote. And they are quoting to the October 10th transcript on page 26. Because certain relevant new information has come to light since the detention order, Mr. Combs intends to file a renewed motion for pretrial release on conditions with an updated proposed bail package in the district court. So what they are alleging, according to this, is they got some new information that has come to light that should assist him in his argument and the proposition that he should be out on bail. He has also indicated they have done a revision of whatever this bail packet is. They have done the previous one that was putting up the house that was worth like 50 million, having your mama's house up there on, a part of it as part of the bond. He was going to be on tether, he was going to have cameras, he was going to have security, only certain people could come in the house, he can only go to certain states, all of that. Apparently they done came up with some other ways of which he should be able to be out on bond, and it would satisfy the court's concerns that they may have had about flight risk, and I guess allegedly talking to any witnesses and people that are scared of him. So I don't know what this new information is, but I hope they file it in their motion when they file it, because I just want to know, what do you guys think it is? What could it be? I don't know what it could be. What new information? They said because certain relevant new information has come to light since the detention order, Mr. Combs intends to file a renewal motion for pretrial release on conditions with an updated proposed bail package in the district court. The renewed request is based on changed circumstances warranting a new bail hearing, which the district court is best suited to consider in the first instance. And then they cite to 18 USC section 3142 sub F sub 2, and which says the hearing may be reopened at any times if the judicial officer finds that material information exists that was not known to the movant at the time of the hearing. I need to know. Can somebody get Diddy's attorney on the phone? Because I need to know. What could this be that you feel like this is so material that this should be reconsidered by the court? Do you think, I don't know, what new information could it be? You guys can take some guess because I literally have absolutely no clue. I was thinking perhaps they really, really wanted somebody else and he was able to give that type of information for that somebody else. But this is not what they're really saying, because it's not like the government is joining in on this motion. As we'll see later on in the document, they're not joining in. I think they would join in if it's something where they changed their position. But he's saying he got some more information. Somebody said he's sick and he needs complex medical attention. Okay. That's an interesting speculation, because we're just speculating. We're just speculating on what this could be that could change the whole trajectory of the landscape of this bond. Very interesting. So let's go on. If the district court grants the motion or issues an indicative ruling that it would do so, Mr. Combs will move to dismiss his appeal as moot. On the other hand, if the district court denies the motion and Mr. Combs appeals that ruling, the two appeals can be consolidated and the matter adjudicated on a full record before this court rules. So what they're saying is, we want you to pause this case in the Court of Appeals. We are going to go back down to the district court and we're going to see what the district court has to say. And if the district court gives my client bond, then we don't need the Court of Appeals. It's moot. Doesn't matter anymore because we got what we wanted in the lower court, in the district court. However, if the court decides that they're going to go against us as well and they're going to continue this denial, we can consolidate, because we're going to appeal this too. So we can just consolidate it and still, go to the Court of Appeals and not have to refile and redo number, get a new case number and all of that. We'll just consolidate them together and we'll argue it as one big argument. Tracy said, Clive, you in danger. Diddy gonna turn on you? That's what Tracy's speculation was. We are just speculating right now because I don't know what this new information can be, and it hasn't been filed yet. But Tracy, you be on the lookout, okay? You be on the lookout, because am I done for the day? It's 4:00. I don't know. Let me see. Let me look at my calendar real quick. I got one more thing at 5:00 and then I'm done for the day. So yeah, Tracy, you be on the lookout because we want to know. As soon as this is filed, we're going to be back up here because I need to know. Now, what if they say this new information, they're going to put it under seal? I'm going to be very upset because now you got us invested in this and we aren't going to know what it is unless we actually go to the bail hearing. Early Morning Vibe said Diddy is grasping for straws at this point. I call it zealous advocacy. If you were in prison, your loved one was in prison, or anybody else, you want them to fight. And I'm sure he's paying them a whole lot of money for them to be out here. Even if a lot of stuff, even if you windmill, every now and then something connects. So I think they're doing their job because it is best to have your client out than in. when it comes to preparing for trial. I do agree with that. It seems like it would be difficult. You got to come into the jail when they let you to. They only allow you certain things in the jail. When Diddy has to look at these videos, they've already set it up where it's going to be in some room where he can view them or whatever, the data that they've downloaded, which is a lot. Hours and hours. You're talking about years, decades of audio and video. But yeah. And Tracy said, I need them to stop stealing stuff. I'm too nosy for all. That's what it's like. They give us a little bit and then they just snatch it away. You know what I'm saying? It's a case. One of the cases is under seal. There's another case. I don't know if you saw it, Tracy, but there's another case in New York that's in state court and it's under seal. So yeah, they are sealing some of these cases and some of the information that's in the cases. So it's going to be because see, at first I was thinking, well, maybe the government is going to agree to this, but let's keep reading. It will promote efficiency and preserve the resources of the court and parties to hold this appeal in abeyance until after the anticipated proceeding in the district court are completed. And they cite United States v. Owens as its authority, which discusses cases where appeal held in abeyance pending factual hearings and resolution of Rule 33 motions in district court. Accordingly, Mr. Combs requests that this court hold in abeyance these appeal proceedings pending the district court's decision on his renewed request for pretrial release on conditions. If this motion is granted, Mr. Combs will promptly update this court of any such decision in due course. We contacted the prosecutors to request their position on this motion, and they advised us that the government plans to oppose this motion and file a response. Although the government suggested that we dismiss the appeal if we pursue a renewed motion for bail in the district court, this court's preferred practice is to hold the appeal in abeyance pending further district court's proceeding. So they reached out to the government and was like, hey, can you stipulate and agree that we are going to ask the appeals court to hold off? And they were like, no, we're going to oppose it. If you want to file a renewed motion, then you should dismiss your appeal and then just go in the district court. So they're not even on the same page about how this should be going procedurally. So then they cite United States v. Camacho, which stands for the position of parties seeking reconsideration on Rule 33 motion should, quote, move in this court for the briefing and the pending appeal to be deferred or held in abeyance pending district court's decision. Now, again, like I said before, we did have where yesterday, I don't know if I even got that up. Yesterday, the government did file. Is this it? No, that's the same thing, huh? Oh no, this is one of these another case that got filed yesterday on Diddy. So that ain't it. Look, I got so much stuff with Diddy's name on it on my screen. You would think that I dang near represent him or one of these people. Let me see. I don't think I did. I download it. Let's see. So they did file a lengthy response, and we're not going to go over all of that because I said we weren't going to be on here that long. But this was the affirmation and opposition to defendant's appeal of an order denying pretrial release. So this is from the assistant prosecutor's office, and they did a nice lengthy thing going on here, talking about the initial bail hearing. Lord, the bail hearing before Judge Carter. So they aren't agreeing, they're not conceding. They did their argument that the district court properly denied the motion for bail. Judge Carter's dangerousness finding. Now, this is interesting. So they basically say, let me see. So, in addition, as charged in the indictment, Combs engaged in other acts of violence, often assisted by members and associates of the enterprise. As the government explained below, the allegations in the indictment are supported by detailed and credible testimony of dozens of victims of and witnesses to Combs' physical and sexual abuse, as well as extensive documentary and electronic evidence. This includes financial and billing records, travel records, electronic media, example, video, photos, and audio files. Communications, including communications by and with Combs. It also includes evidence seized and executing multiple search warrants for cloud accounts, electronic devices, and Combs' person and premises, which yielded cell phones, laptops, cloud storage accounts, as well as physical evidence such as freak-off supplies. That's where that baby oil come in, I guess. Firearms and ammunition. So the government argued before the judge that Combs posed a danger to the community and risk of flight. So those were the reasons why they're saying, because the purpose of bond is just to ensure that you're going to come back to court. That's really supposed to be the purpose. And I think sometimes they get away from what the purpose is. So the government provided an overview of the conduct charged in the indictment that demonstrated Combs' dangerousness, including Combs' decades-long pattern of physical and sexual abuse of victims, as well as other violent acts perpetrated by Combs and members of the enterprise. The government also highlighted Combs' obstructive conduct charged in the indictment, including bribery and witness tampering. So this is what the government highlighted in order to say bond should not occur. The government highlighted an incident that took place in March 2016 during a freak off at the Intercontinental Hotel in Los Angeles, California. During that incident, Combs violently assaulted a female victim in the public elevator bank as she attempted to leave the hotel. So this is the video we saw about Cassie. And of course, the defense argued that was his girlfriend, wasn't a random chick. They were in a volatile relationship, and they gave their explanation to what happened before that occurred. Combs punched the victim, threw her to the ground, kicked her, attempted to drag her back to the hotel room, and then threw a vase at her. This violent incident was captured on hotel surveillance footage, which was publicly released by the media earlier this year. When hotel security staff intervened, Combs attempted to bribe the security officer, offering him a stack of cash in exchange for his silence. When that security officer refused Combs' bribe, Combs directed his staff to contact other members of the hotel security staff to obtain the surveillance video and to reach out to the victim to ensure that she would not report Combs' assault. Within days of the incident, as a result of Combs' bribery efforts, video surveillance of the incident disappeared from the hotel server. It might have disappeared from the server, but it didn't disappear off this earth. That's for sure. Combs continued his obstruction well into 2024 after a civil lawsuit was filed against Combs in November 2023, detailing, among other allegations, the March 2016 assault. Personally and through his attorney, denied assaulting the victim. After the video, the March incident was obtained and published by a media outlet in 2024. However, Combs was forced to admit that he had in fact engaged in the assault that he had described as baseless and outrageous lies. Now I do agree, I am not understanding how that's considered obstruction, because when you respond to lawsuits, you usually do either you do deny it or you leave them to their proofs. And I guess they came with their proof later on. So he was like, oh, okay, maybe that did happen. So I don't know, but they did use that information. The government also described evidence of multiple additional assaults by Combs against victims, including choking, hitting, kicking, and dragging victims, often by their hair. These assaults caused significant injuries to victims, which often required long periods of recovery. The government detailed multiple incidents in which Combs or people acting on Combs' behalf reached out to potential victims and witnesses, including witnesses who had received grand jury subpoenas. The government describes Combs' attempts in November 2023 to feed a potential victim a false narrative in exchange for Combs' continued financial support. as the government also proffered after another civil lawsuit which detailed violent incidents during the period of the charge racketeering conspiracy was filed on September 10th. Combs was in contact with the potential witness to the lawsuit's allegations 128 times between September 10th, 2024 and September 14th. On September 13th, the witness made a public statement denying that she had witnessed the abuse described in the civil lawsuit. So that's pertaining to the Don Richard and her bandmate from the Diddy Dirty Money. So you can almost like know the names that they're talking about. So that those are the reasons why they are saying that he should not have been out on bond. A lot of it is based on the civil lawsuits that were out, is what they're saying. So nonetheless, if you're just coming in here, I want you to hit that like button. That's the first thing, and subscribe to the channel if you have not done so already. But the gist of it is this: although Sean Combs is scheduled to argue in front of a panel of appellate judges November 4th of this year, it sounds like Sean Combs is alleging that he has new information of which he did not have at the time that he argued this bond. And he has also restructured the package in order to go before the judge. Because remember, he got a new judge. So now this new judge at the end of the status conference, which usually is no big deal, it's just because it's Sean Combs that people are in the courtroom tweeting and all of that. Because most of the status conferences that I've had in federal court, they're in chambers. Like they're not even out for the public. But nonetheless, because it is Sean Combs, it's a major media situation, and he actually came to this. They let him come to the status conference, and that's a place where that's a situation or a conference of which you talk about dates and discovery and what the cutoffs are and trial dates. That's where we got the trial date for May 5th. Well, apparently at this conference, the status conference, which is October 10th, the judge made a comment, which I did see in one of the tweets, that there wasn't an application of bond before him at that time. So he wasn't entertaining it because nobody had requested one in front of him. But apparently he also said that if Mr. Combs wanted to do a bond request or a motion for bond in front of him, that he would entertain it. So now this attorney has asked the Court of Appeals, hey, hold off 1 second. We may not need you, but we may need you. So I don't know. But I don't want to start this process all over again. So can we just put a pause in here, put a pin in it real quick? And I am going to file this motion because I have some new information that I didn't have before. And I am going to present it in front of this judge and see if he goes for it. So that is what is happening. And that just happened today. But yeah. Miss Buckeye said Diddy is really reaching. I just want to know what it is. That's it. I'm with you, early morning vibes. I just want to know what it is. Hey, Nesta, good to see you. I just want to know what it is. Because what could it be that changes the trajectory of everything? What information did you find out that it's just going to change everything in your mind? That doesn't necessarily mean that it will. And you better not come with some old bogus stuff, because we're going to call you out on that, having us anticipating this new information that you're alleging that you have. And then we go and we're like, that's what he's talking about? Oh, that was whack. You guys think it's going to be disappointing? So what I'm talking about is this is a document to hold it in abeyance, and it has, because certain relevant new information has come to, well, let me go up first. So because certain relevant new information has come to light since the detention order, Mr. Combs intends to file a renewed motion for pretrial release on conditions with an updated proposed bail package in the district court. The renewed request is based on changed circumstances warranting a new bail hearing. What was the change of circumstances? Which the district court is best suited to consider in the first instance. So, this is information that allegedly was never heard in the district court. And then they have the statute that they cite, which says the hearing may be reopened at any time if the judicial officer finds that material information exists that was not known to the movant at the time of the hearing. So this is some new information that allegedly they find. Maybe it was they starting to turn over discovery and they're looking through some of the discovery and they found some stuff the state said that maybe wasn't all the way, it wasn't complete. I don't know what it could be. But we'll be back on whenever they file it if they put it in a pleading. Boss lady said, girl, nothing. Did he try anything to get out? You don't think you think they just wasting the court's time? You think they're wasting the court's time? In my curiosity. Somebody else said that about the medical treatment. Okay, Miss Buckeye said you guys are bluffing. That's what she said. She said she said, Diddy, you're bluffing. You don't have no new information. She said stop the cap. That's what she said stop the cap. Let me see. Let me look and see on here if anything was filed yet. Nope, I don't see anything filed yet since the 15th in the district court. And today is the 17th, so nothing new yet. And Pat said probably here. You guys are definitely leaning towards some medical stuff, huh? I don't know. I think he probably knew whatever. I don't know, because it's supposed to be information you don't know. So we shall see. We shall see. You guys make sure you hit that like button, subscribe to the channel. I was just coming on here for a minute to let you guys know that we do have a new filing in the Court of Appeals, and we won't be having an oral argument on November 4th if Diddy's attorney has his way, of which she wants to hold off on the appeal so that the other attorneys can go ahead and file something in the district court. I told you these attorneys are not doing anything but Diddy's work at this point, because I don't see how you would have time to even entertain any other clients when you got terabytes worth of discovery, and then you got your client in jail and you're trying to get them out. You got appellate stuff going. You got district court going. Then the civil attorneys, they get no rest. Civil attorneys get no rest at all because they're getting new lawsuits. It was one filed yesterday. Then you had the lawsuit of the young lady that is claiming that Diddy got mad at her on the FaceTime because she said you had something to do with Tupac's unaliving. I think that is a very interesting allegation to just randomly make, but nonetheless, she said you got something to do with Tupac's unaliving. And he said, oh, okay, all right, you gonna see me one day. So then allegedly her friend who was FaceTiming Diddy at this bar or spot or wherever they were at was like, hey, I need my medication because I have cancer. And then she's like, okay, I'll come help you. So then she goes over there, and then basically it's looked like a setup, because next thing you know, she's in her apartment and Diddy busts through the door and he's like, what's all that crap you was talking? What's all that stuff you was talking about? I did something to Tupac. Say it now. I told you you was gonna see me. And then said the young lady, that's his assistant, she allegedly was there as well, and said that she was there she puts IUDs in people before he was about to Say her. Listen, it's definitely an interesting situation. She went and got knives. It was some nice knife play, and some security guard that was there got mad at Diddy too for saying I did do something to Tupac. So he shot up in the air or shot at Sean Combs, and then Sean was scared and ran, and then she whipped out the knife that she was holding up under her sleeve, and she went to slice him up. But that was all after he raped her with a remote control. So I'm just saying, the stories just keep coming and they keep coming. And then there was another one, like I said, that was filed, I think it was yesterday. It was and that case is the case that, remember, the attorney Ariel, who was representing Ariel Mitchell Kid, who was representing Adrena English, that was talking about, went on the different shows and was talking about shopping a tape at, I think it was News Nation that she said that on, but she was saying that people were trying to shop a tape and it was a high celebrity and the celebrity was bigger than Diddy and all of that. And she ended up withdrawing out of English's case. That's the case that she took on. The one of the young lady that said that she got essayed by the remote. And then she came back to the house after Diddy left, and she spent the night over the friend house that she said set her up. Yes, it was the remote control. Yeah, I lost you. You guys didn't hear that? I know I didn't go over it because I try not to just go over everything. Let me see. Let me see if I got that. If I got that, I'm not making this up. I don't want you guys to think I'm starting to make stuff up now. I'm just, let's see. I was gonna go over the one from, let's see. So this was Ashley Parham. So the facts are very, very, it's a lot. So you see this says like 63 pages. So she says plaintiff met defendant Shane in February 2018 after an altercation with another man at a bar, and Shane came to plaintiff's rescue. While outside the bar with friends and other patrons, Shane FaceTimed Diddy and was showing people Diddy in the video of her phone, attempting to impress the people with his famous friend. Shane then showed Diddy on his video call, which plaintiff ignored, stating she was not impressed by him knowing Diddy because she believed he had something to do with the murderer rapper Tupac Shakur. Visible in the FaceTime call was Diddy and some of his children, including Christian and Quincy. It appeared from the plaintiff's perspective that Diddy was having a get-together at his house. Defendant Diddy heard plaintiff's statement and made a remark that she would pay for the statement regarding Tupac and overall dismissal of Diddy. So basically, you're gonna pay for acting like I'm not the man, okay? And you said that I killed Tupac. Oh no, sis. That's pretty much what she's saying was said. So then on March 23rd of 2018, Shane invited the plaintiff to his home to assist him with his cancer medication because he stated he was weak and unable to open his medication. After the arrival, Shane informed plaintiff that he wanted to give her a ride to his new car. Plaintiff and defendant Shane left his residence for a brief period and then returned. So my thing is here is like, you invite you over to assist with medication because he was too weak and unable to open the medication, but he's not weak enough to drive you around in a new car. Once they returned, Shane left the door to his apartment partially open and stated the door was ajar because there was an issue with the door where he couldn't close completely. So Shane was renting an apartment on the lower floor in California. Shane had a separate entrance in his residence that led to the backyard. So Shane rented a home from a woman who lived upstairs. Plaintiff and Shane then began to watch a movie, and Shane offered a glass of water, which he retrieved through which he retrieved and brought back to the plaintiff. So she came over there to get him medication because he was weak, but he taking her on rides and giving her the drinks, like the water and all of that, like catering to her when she's there. 10 minutes after plaintiff and Shane returned from the drive, Diddy entered the residence. And Diddy entered and said, "Ready to party." No, he came in a ready to party manner. His grandiose entrance was so loud that the dogs upstairs began barking. Diddy did not enter the home through the backyard entrance, but instead through the main entrance. Along with Diddy was the bodyguard, defendant Doe 1, a woman who plaintiff later identified as defendant KK, that's his assistant. Another woman, small and skinny build, in early 30s with blonde mid-length hair, who plaintiff has still been unable to identify. Jane Doe, defendant Doe 2, who upon information and belief is a friend of Shane and Diddy, and defendant Diddy's driver, Doe 3. So they got a lot of Does because they don't know who these people are. And Doe 3 remained outside during the assault. Plaintiff believes that Shane invited her over to set her up to be assaulted by Diddy because of the statement she made about Diddy a month earlier about killing Tupac. So then at Diddy's arrival, he immediately began to antagonize the plaintiff, stating, quote, she thought she would never see him in person, pay for her statements about Tupac during a video call, and that defendant Diddy caught plaintiff. Plaintiff was in shock as she never believed that she would ever see or meet Diddy in real life, let alone in the small apartment rented by Shane. Diddy then began advancing towards plaintiff, who was sitting on defendant Shane's bed with a knife. So defendant Diddy then began advancing towards where plaintiff was sitting on defendant Shane's bed with a knife and held it to the right side of plaintiff's face and threatened to give her a Glasgow smile in retaliation for her previous statements on the video call. So then KK told Diddy that she did not think giving plaintiff a Glasgow smile would be advantageous to their potential client, who they could sell plaintiff for sex. So basically, Diddy, don't slice her face up because we could use her on our X ring or something. That's basically allegedly what the assistant said. So then his assistant said, then the assistant then made a threat to the plaintiff that they would ship her off anywhere in the world and that she would never see her family or anyone she knew ever again. So then Shane partially undressed plaintiff, and then Diddy removed the remainder of the plaintiff's clothing, removing the knife from her face, and then retrieved a bottle of liquid from a large fanny pack. So then Diddy squirted a bottle of the liquid on plaintiff, which placed her in fear that she was being squirted with the chemical substance like acid. But plaintiff soon realized that the substance was an oil lubricant. Plaintiff was squirted with this liquid substance over the entirety of her naked body. So this is where the lubricants were laced. It came from a civil lawsuit. Now people were saying proof that there was stuff in the, that wasn't from testing, that was from this lawsuit. Defendant KK was then told by Diddy to insert what looked like a syringe from a sterile package into plaintiff's vajayjay. Defendant KK did as told and then told Diddy that she was unable to use the IUD because it had prematurely been released from its packaging. So Diddy was upset and took the syringe and tried to insert it in the plaintiff himself. And then Diddy began to argue with his assistant, who continued to advise Diddy that since the IUD had been prematurely released from its packaging, there was no way they could insert it in her vajayjay. After some time, Diddy heeded the advice of defendant KK and removed the syringe from the vajayjay and handed it to defendant KK. So then KK is the assistant. So then the assistant and Jane Doe then exited Shane's residence, leaving plaintiff alone with Diddy, Shane, Doe's 1 and 2. So she's left alone with 4 people. Diddy then picked up a television remote that was near plaintiff and violently inserted into plaintiff's vagina. Defendant Diddy, while violently raping I'm saying all the words, Lord, essaying the plaintiff with a television remote, told plaintiff that her life was in his hands and that if he wanted to, he could, quote, take her and she would never be seen again. Plaintiff began hysterically crying from the threats by Diddy, along with the pain of being violently vaginally raped by Diddy with the television remote, as well as the lingering pain from the ordeal with the IUD. insertion. So then Diddy instructed Shane to turn plaintiff on her stomach, seemingly tired of hearing the plaintiff's blood curdling cries. So then Shane grabbed plaintiff by her abdomen and hips and turned her on her stomach. So then Diddy instructed Shane to put a pillow over her head because he ain't want to see her face or hear her cries, and instructed Shane to anally assay her. Then Shane did as he was told by Diddy and began to assay her. So then Diddy violently essayed her, and behind there too, after Shane. So then Doe 2 joined, and Diddy and Shane taking a turn to essay her. Immediately after Doe 2 essayed plaintiff, he exited Shane's residence. So defendant Diddy then instructed defendant Doe 1 to also essay the plaintiff. Instead of immediately assaying plaintiff, defendant Doe 1 doused plaintiff with more of the oil lubricant and then jumped on top of plaintiff's body, treating it like a slip and slide, and knocked the wind out of plaintiff due to his enormous size. So then Doe 1 caught himself from sliding over the plaintiff's oil body and off the bed. He then began essaying plaintiff in the vajayjay. While defendant Doe 1 was essaying plaintiff, Diddy sat in a chair near the bed and began pleasuring himself while recording the essay of defendant Doe 1. Another party's phone fell on the bed near plaintiff. Plaintiff then attempted to grab the phone, but it slipped out of her hand into the floor due to the oil that she had been doused with all over her persons by defendant Diddy and Doe 1. Diddy began laughing at the plaintiff's attempt to grab the phone. Throughout the violent gangbang style essay, Diddy made constant belittling remarks to plaintiff, including that he owned her now. So plaintiff's body was becoming more and more limp over the course of the essay until eventually she had no control over her body, nor could she move her body. When defendant Doe 1 finished essaying plaintiff, the assistant entered the room to examine the condition of plaintiff, who was barely able to move or control her bodily functions. So then the assistant examined the plaintiff to see if she needed assistance and was about to give plaintiff an IV of fluids. But plaintiff cannot be certain if she did or did not receive such intravenous intervention. So she don't know if she got the IV or not. But the assistant then opened a different bag, different than the one Diddy removed the oil from, where plaintiff observed several medicine bottles, IV fluid bags, and other unidentifiable powder-like drugs. Defendant, the assistant, then removed a pill from one of the medicine bottles and gave it to Diddy. So then Diddy inserted the pill into plaintiff's mouth and down her throat to where plaintiff had no choice but to ingest the pill. So then now you got Diddy, Shane, the assistant, and Doe 1. They exited the residence to the backyard where they smoked marijuana and cigarettes. So plaintiff remained in an almost lifeless state in Shane's bedroom until she finally regained her bodily function. Plaintiff then began looking for her clothes and her purse, and that contained her car keys and cell phone, but could not discover them in the room or anywhere in the apartment. So the plaintiff was only able to find a t-shirt on the floor, where she put it on over her naked body. Plaintiff also observed a black condom wrapper on the floor at the bedroom, which she assumed was used by one of the defendants, most likely Diddy, during the essay. Plaintiff then grabbed a knife from the kitchen and headed to the backyard where the defendants were smoking, as that was the only way to exit the premises into the street. So plaintiff concealed the knife on her left side as she exited the apartment to the backyard. Upon coming to the exit at the home, which led to the backyard, plaintiff was met by defendant Doe 1, who was standing at the door between the residence and the backyard. By the time plaintiff was able to compose herself and come to the backyard, the assistant was no longer in the backyard, but upstairs on the patio balcony with Jane Doe. So then defendant Doe 1 allowed plaintiff to walk to the backyard where defendant Shane and Diddy was still smoking. Defendant Doe 1 did not see the knife that plaintiff concealed on her left side, as it was obstructed by the oversized t-shirt that plaintiff was wearing. See, I'm not making this up, y'all. I was just giving you guys the cliff notes. Plaintiff observed defendant Diddy still partially nude from the assault while defendant Shane and Doe 1 had on their clothing. So then Shane left to go upstairs portion of the patio where defendant, assistant, and Jane Doe were already situated. Plaintiff then sat down on a makeshift seat in the backyard when defendant Diddy noticed her presence and remarked that he was surprised she was able to walk because he had given her enough drugs to take out a horse. Plaintiff then asked Diddy what he gave her, and he laughed, did not provide a response. So then Diddy made further comments to plaintiff in a jovial, friendly manner, asking her why they hadn't partied together before. It was so much fun, and he hadn't had any behind that tight in a while. So then Doe 1 then quit at Diddy and was like, you probably hadn't had any behind that tight because you're not used to having it with a woman. And then Diddy and Doe 1 laughed about that. So we know what that inference is. So then plaintiff told Diddy she did not party with him and she did not enjoy partying with him and that he SA'd her. So then Diddy did not like plaintiff's response to his lighthearted commentary and offered plaintiff money and instructed plaintiff to say that the SA was consensual and that plaintiff was an ex-worker. So then plaintiff became enraged and she yelled at Diddy that her SA was not consensual. She was not an ex-worker and she refused to take any money from him and would tell the police that he had RA'd her. So then Diddy told the plaintiff no one would ever believe her that she had got SA by him, and if she did tell anyone, such that they would harm her family. So then defendant Doe 1 showed a phone to the plaintiff that looked like her estranged sister's residence, as she could see her sister sitting on the couch and her sister's spouse on the balcony. It looked as if someone was outside the residence streaming the video to defendant Doe 1's phone. So then the plaintiff, while rattled by what she was seeing on defendant Doe 1's phone, was still angry about being RA'd and was gang RA'd and was not complying with Diddy's request to take the money, being offered to say that it was consensual. So then he calls his mother, and I guess the mother allegedly was trying to convince her to not call the police. And she was like, but your son just SA'd me. So yeah, I'm trying to call the police. So then Diddy then made further threats that he had gotten off from bigger crimes than this and referred to Tupac again, further antagonizing the plaintiff. So then Doe 1 then turned to defendant Diddy and pulled his gun out on him, asking him to repeat what he said in reference to Tupac. So whoever Doe 1 was didn't like the Tupac story either, or Diddy trying to infer that he had something to do with Pac's demise. And so he was like, say that again. So then as the two of them were exchanging words, plaintiff went behind defendant Doe 1, where he seemingly began to protect plaintiff. So now Doe 1 is protecting the plaintiff. Like, I got this. He talking about pot. Like, you can't talk about pot. Like, I draw the line on pot. So then Doe 1 then advanced to defendant Diddy, questioning him over the comments he made about pot. So during this commotion, a neighbor directly across the street came outside and peered into the backyard and asked what all the commotion was about. So Doe 1 pointed at the neighbor and was like, mind your business. Mind your business and go back inside. So then Doe 1 turned the gun back on Diddy and was like, back to what I was talking about. So plaintiff, not far behind from defendant Doe 1, tried to grab defendant Doe 1's hand that had the gun. So then the gun then went off because they struggling. So then the gun goes off and it hit a hill behind the residence. Okay. So then Diddy ran up back stone stairs near the hill in the backyard towards where his assistant was, Shane and Jane Doe were. He ran because the gunshots, boom, boom. So he ran. So then plaintiff charged towards defendant Diddy, moving the concealed knife from under her hand, her right hand. And she was like, whoosh, and she just whipped it out and she was running after Diddy. So then the plaintiff pushed Diddy from behind while on the stone stairs, causing him to fall with his back to plaintiff. So then plaintiff raised up the knife in her rage from the events that just transpired and with the intent of driving into Diddy's neck or back, when he turned around and began pleading for his life. Plaintiff, shocked now to see defendant Diddy acting as a victim, had a moment of clarity and then turned and ran down the outdoor stone staircase back out of the backyard to escape. So she felt sorry for Diddy after she had the knife. She felt sorry for him. And she ran back down the stairs so she could escape. So then Diddy chased the plaintiff down the stairs and attempted to push her, but she was already at the bottom of the stairs and gained her footing and wielded the knife at Diddy, grazing his abdomen. So she cut him. Hearing the commotion, the assistant and Jane Doe emerged, and KK then began administering first aid to Diddy for the injuries caused by the plaintiff. Plaintiff tried to make quick dash for the exit, but it was thwarted by defendant Doe 1. After a period of time, plaintiff was able to abscond from defendant Doe 1 due to the first aid commotion with defendant Diddy, and was able to run down the street. One plaintiff made it on the street. Once she got to the street, she started yelling loudly, "Somebody help, call the police." So then defendant Doe 1, who had now caught up with plaintiff, advised plaintiff that he was an undercover cop. To this day, plaintiff is unsure of the truth or falsity of that statement. So Doe 1 apparently was saying he's an undercover cop, and so she doesn't know if that's true or not. The same neighbor then again emerged from his residence asking what was transpiring. Just as plaintiff was attempting to answer, gunshots began being fired in plaintiff's direction. Plaintiff fled to a car near where the neighbor was also taking cover and lost sight of defendant Doe 1. Plaintiff then heard an SUV screech off and speeding, leaving the residence. Plaintiff then entered the home of the neighbor, who informed her that he had already called the police. Plaintiff informed the neighbor that it was Sean Combs who had essayed her and shot at them, but the neighbor was unaware who defendant Diddy was. Shortly thereafter, a sheriff from Contra Costa Sheriff Department arrived at the neighbor's home. Plaintiff told sheriff she had been violently gang essayed by defendant Diddy and others, and that she did not have her clothes, phone, purse, car keys, or cell phone. And then the sheriff told her and the neighbor that they had received several noise complaints prior to the neighbor's call, and instructed her to find a way to get home. So the sheriff came over. You telling the sheriff you just had this violent attack, and then the sheriff was like, "You don't have your keys? Well, you need to find a way to get home. We're not going to call the EMS. We're not going to do any. You're not going to say, do you have any relatives? None of that." The sheriff did not offer to take plaintiff home, nor did he call for emergency services, including the ambulance, nor any offer to take plaintiff to the hospital, nor any offer to help plaintiff recover her clothes or effects from defendant Shane's residence. The neighbor offered to let plaintiff sleep on his couch until he could figure out a way to get her possession and get home, but plaintiff declined and only remained at the neighbor's residence for a short period of time once the sheriff left. Plaintiff then went back to defendant Shane's residence, where she found the door open and her clothes were readily accessible in the residence. So Shane then emerged as if nothing happened, transpired, and offered for plaintiff to stay at his residence while she slept it off. So she came back, and the guy Shane was like, "Hey girl, where you went? Where you go? I didn't know, I thought you left and went home. Yeah, you kind of blow. So why don't you just go ahead and take a nap here and sleep here for the night?" Plaintiff asked for her purse and her keys, but defendant Shane told her she shouldn't leave in her condition, and plaintiff, catatonic and in a state of shock and disbelief for the events that transpired, stayed at defendant Shane's home while defendant Shane left the home. So she stayed at his house and then he left. So later that morning, defendant Shane returned to the residence and woke plaintiff up and finally gave back her purse, cell phone, and keys, and plaintiff left defendant's residence. In a daze, plaintiff returned home and tried to make sense of what happened to her. On March 26th, plaintiff contacted her primary care doctor and asked for an HIV and STD test in fear of possibly having contracted the disease from her violent essay. Plaintiff tried to continue her life as she felt she wouldn't be believed, as plaintiff already had told Contra Costa Sheriff's Department about Diddy, and they didn't do anything. So further, plaintiff was under the impression if she did continue to say that Diddy's name in relation to her assault, she would not be believed and her family would be in danger. Seemingly mere days, maybe even the days before plaintiff's vicious attack, defendant Shane had miraculously begun driving a new car. So after the attack, she's saying that her friend Shane ended up getting a new car. Plaintiff believes this was payment by Diddy for setting up this essay. A few weeks later, April 2018, plaintiff, still in pain and reeling from the horrific assault, went to the hospital as her injuries had not subsided from the assault. The hospital conducted several tests on plaintiff, including her assay kit, ultrasound, and x-rays. Additionally, plaintiff was given IV fluids to stabilize her vitals as she was in severe weakened state from being unable to eat and losing a substantial amount of weight since the essay occurred. While at the hospital, plaintiff told members of her treatment team about her horrific assault, and they then contacted the Walnut Creek police. So Walnut Creek police showed up to plaintiff's room and took a statement regarding her assault on March 23rd. Plaintiff had already told Contra sheriffs about her essay that it was defendant Diddy who orchestrated it on March 23rd, which was ignored. So plaintiff declined to refer to defendant Diddy again to the Walnut Creek police because she believes she would be ignored by the police. So she basically told them that she was assaulted by defendant Shane Doe. So she went to the hospital. She's alleging she went to the hospital. They called Walnut police, and because the other sheriff's department didn't do anything when she named Diddy, she said, well, let me just leave Diddy's name out of it, and I'm just going to blame Shane Doe and leave Diddy's name out of it. Plaintiff believes her statement made to Walnut Creek police while at the hospital was captured by police body camera footage. Plaintiff further believes her statements made to the Contra Costa sheriff on March 23rd, immediately after the vicious assault, where plaintiff named defendant Diddy directly and by name was captured by body cam. Plaintiff also filed a report to the Orinda Police Department on April 17th of 2018, but again was too afraid to name Diddy. So she done filed, this is 3 different police departments. The first one she named Diddy, they didn't do anything when they came to the house. The second one, she said they came to the apartment. The hospital. She said she didn't name Diddy because she felt like they weren't gonna listen to her if she named Diddy, so she just named Shane Doe 1, who is, I guess, supposed to be the undercover police officer, according to him. Then you have the Orinda Police Department. She contacted them on April 17th, but again was too afraid to name Diddy as one of her assailants, so she did another police report where she didn't name Diddy. During this report, plaintiff provided her clothing to police from the night of the assault, but they only retained her underwear. To date, the underwear was never returned, and plaintiff believes no investigation ever commenced. So they took her drawers, and then they never did anything, according to what she believes, that they didn't do anything with her. Plaintiff sought assistance from a therapist in May of 2018, one of which tried to have her therapy appointments covered by a victim's compensation fund, which was rejected because plaintiff was told no law enforcement agency had opened an active investigation into any of her many reports of her gang essay. Subsequently thereafter, plaintiff asked police for a copy of her report from the Walnut Creek Police Department on July 19th of 2018. Plaintiff was provided a letter from the Walnut Creek Police Department stating that it was, quote, unable to furnish this information as it is confidential and not subject to public release, end quote, despite plaintiff not being the public and the victim and complainant. In March of 2024, plaintiff was re-traumatized by all the events surrounding Diddy, including the several civil lawsuits against him, as well as the raid of his home. Plaintiff called Contra sheriffs again in hopes of renewing her previous complaint and amending it to ensure Diddy's name was included. So she wanted to call the police, sheriff's department, so she could amend the complaint once his house was raided. And once all these people filed civil complaints, she wanted to amend the complaint so she could add him down too, like she added the other people. Plaintiff received no response from the sheriffs. So then July of 2024, then emailed the chief of the sheriff's office regarding her complaint, lack of investigation, and how she was treated by the initial officer. Plaintiff then later received a call back from a detective, but then nothing further. Plaintiff then began seeking legal counsel for her claims, ultimately being referred to undersigned for representation. Undersigned counsel also attempted to get a copy of the 2018 police report from Contra Costa Sheriff's, but was told that they would not provide the report or any other information without a subpoena. So the first cause of action she had was racketeering, was the RICO. Second cause of action was another RICO. Third cause of action is sexual battery. Fourth cause of action, I'll skip one. Fourth was sexual assault under California Code. Fifth is sexual assault, sexual harassment under the California Civil Code. Sixth is battery. Seventh is assault. Eighth is negligence, and that's just to defend to shame. The ninth is negligent failure to warn, which is just towards Shane, his assistant, Doe's, Jane, and Jane Doe. We got 10th cause of action is negligent supervision and retention. That's against Diddy. And then you have 11th cause of action is intentional infliction of emotional distress. That's against all defendants. 12th cause of action is negligent infliction of emotional distress. That's against all defendants. The 13th cause of action is unjust enrichment, and that's against Shane, the assistant, those 1 through 3, Jane Doe. The 14th cause of action is aiding and abetting, and that's against defendant Shane, KK, Doe's 1 through 3, Jane Doe. The 15th cause of action is Trafficking and Victims Protection Act, and that's against all the defendants. The 16th cause of action is aiding, abetting, and inducing an ex-trafficking venture in violation of Trafficking Victims Protection Act. 17th cause of action is knowing beneficiary in ex-trafficking venture in violation of the Trafficking Victims Protection Act. And who is that against? Against defendant Shane, the assistant, those 1 through 3, and Jane Doe. 18th cause of action is obstruction of the enforcement of the trafficking victim. And that's against Shane, KK, those 1 through 3, and Jane Doe. 19th cause of action is false imprisonment, and that's Diddy, Shane, KK, those 1 through 2, and Jane Doe. And then that's it. As you guys see, Ariel Mitchell was one of the attorneys on there. And that's that. Was that a lot or no? I know that's not what we're here for. So you guys always have me go all up on the tangent. Then there was another one that was filed yesterday. You might as well just get it all out the way right now. Let me see. So this is one of the ones I believe is a part of, is it Busby? Is this one of his? Yeah, Busby's cases. So his factual allegations are usually pretty. So this is a factual allegation. And this is against, let's see, Sean Combs, Daddy's House, Combs Global, Combs Enterprises, Bad Boy Entertainment. Okay, all of the Bad Boys records and all of that. And also, no, I did this one. This was the one with Macy's. So I did that one already. Oh, man. Let me see. It was another one I literally just pulled up. Let me see. Let me see. This was a college student, I believe. So this one was against all the same people, and it was also Marriott. Was also in this one as well. So let's go to the factual allegations. Combs and his staff regularly invited members of the public to events such as music video shoots, photo shoots, autograph signing in and around New York City. One such event took place in 2004 across the street from Jane Doe's college campus in Brooklyn, New York. Through Miss Doe's friends and Combs' accomplices and agents, Miss Doe received an invitation to his photo shoot. She was 19 years old at the time. She was flattered and excited to receive such an invitation from an individual of Combs' celebrity and stature. Miss Doe accompanied her friends to the event and discovered that it was a photo shoot promoting the band. So this is okay. This is from that Making the Band show, a recording group Combs signed to his record label Bad Boy Entertainment. At the photo shoot, she and one of her good friends, another freshman living in the dormitory with Miss Doe, were eventually invited to an after party by Combs' business associates. Before leaving for the party, Miss Doe had met Combs at the photo shoot. Combs told Miss Doe and her friend that they should come to his hotel first for a more exclusive party. Miss Doe and her friend agreed and were taken to a Manhattan area Marriott hotel by a member of Combs' entourage. Upon arriving at the hotel suite, Miss Doe noticed that there were a dozen people there having drinks and listening to music in a relaxed party environment. While attempting to mingle around the party, Miss Doe and her friends were suddenly grabbed and taken to a separate room off from the main party. Miss Doe believed the man taking them to the secure was to be a security guard, so she went with him. But when she asked him where they were going, he simply told her, quote, "You know what you are here for," end quote. After taking Miss Doe and her friends to the bedroom, the security guard left the room and locked the door. The only person in the room besides Miss Doe and her friend was Combs. Combs gave Miss Doe and her friend more drinks, then instructed them to cocaine that he had on the table. Miss Doe did not want to do the cocaine. Combs continued getting gradually more aggressive with the two women and eventually began forcibly touching them without consent. When they resisted, Combs ordered Miss Doe's friend to perform oral on him or else he would have them both unalived. Miss Doe's friend complied as Miss Doe begged Combs to allow them to leave. He did not agree. Combs soon turned his sights to Miss Doe and first forced her to take her clothes off, again under the threat of violence. Once she was undressed, Combs forced himself on her and began to actually assault her. Combs fondled, molested, and ultimately essayed Miss Doe, all while she was begging him to stop. Soon and likely due to Miss Doe's cries, the door opened and the security guard from earlier came in to ask if everything was right. It was all right. Miss Doe's friend took the opportunity to rush out of the recently locked door. Miss Doe, however, could not move as Mr. Combs was still on top of her, so her friend left. Combs got off of Miss Doe to talk to the security guard. He left the room but told Miss Doe, "Stay, otherwise she will be unalive." After about a half an hour of sitting in a dark room by herself, another security guard came and told her that she could leave. Miss Doe gathered her things and left immediately and called a taxi back to her dorm in downtown Brooklyn. I don't know what to say. So that is one of the ones that was filed yesterday. So I'm gonna just look at a few of your comments, especially with the first lawsuit that I read that I was like, I'm not gonna read this. But since we were on here already talking about something else, I was like, oh, we go ahead. And that was the first one you heard that someone went to the police and hospital. Yeah, but you do. I mean, it should be the hospital record should be there then. I don't think they said anything about the hospital, but if she went to the hospital, those records should be there. Now, it was a month later. So I'm not sure if you go to the hospital a month later, how do you get a rape kit? I'm assuming there wouldn't be any more. Well, I don't know. I guess you can have semen inside you for a while. But it just seems a month later or 2, 3 weeks later or when she's saying it, I don't know how that will work, but that should definitely be in the records, and if the police came and they came into the hospital, that should be in the records as well. But I do think it's interesting that they're trying to say this baby oil was laced, but and it causes you to be limp. So what were they? They were just so used to this oil that when it touched their skin and penetrated them when they got on top of people, it didn't affect them at all. So I'm not sure about the laced baby oil. I think it's an interesting concept, but it's not just like, oh, you're only going to soak into the skin of the woman, or you're only going to soak into the skin of the victim. If it's a man, it should be soaking into everybody's skin. If you slipping and sliding off of beds, then that should be up in your body as well. But it's going to be interesting because you have all of these people, but unless she has like this neighbor, none of these police reports, because it sounds like there may not be any. You really don't have much corroborating. You're going to have all of these people that are these defendants that's going to basically say, you girl, you're making this up as you go. And you're going to have a jury that probably believes that this is fantastical, because it does sound fantastical when you watch it. I don't put nothing past Diddy at all at this point, but this is a hard sell. Yeah, that's Andrew, especially when they use that slip and slide. That means you can't say it was already soaked in her body if it's affecting you when you're sliding down too. So if she was paralyzed to the point where she shouldn't move, y'all all should have been paralyzed. This ain't no, this only absorbs in your skin. This, I don't know. I don't know, Sky Life. I don't know. It's a good question. TM Mid Sector said this is not the first person I've heard go to the hospital. As long as they got the records, at least to show that the visit was there and what they said it was there for. I don't think they're gonna allege that the people that work there decided to put different information in what they told them, because you provide your history. They ask you, what are you here for? And that's your subjective. I have pain in my leg. I have pain in my, whatever you're there for, that should be memorialized somewhere. Now, as far as the police reports, yeah, if she went to a trauma center and they said they don't have any reports to get therapy as being alleged, and they're saying we have no reports that could substantiate you getting this free service, then it doesn't sound like to me there are any reports. Now, not being able to get those type of reports, depending on where you are, what state you're in. Some states don't even allow you to get police reports. You can only get the cover. I've dealt with that in a Freedom of Information Act situation. You also have some, I know how Georgia is, if things are under investigation, if the case is still investigation and they're investigating it and that's what it's under, then you're not entitled to that report as well. So you will have to subpoena it. And you can only subpoena it like now, because her attorney has filed a lawsuit. Once once she serves them the lawsuit, they're gonna have dates for discovery. She can subpoena and they can give her the report. But I could understand why her attorney would want to get the police report prior to try to corroborate the story that she's telling, because I'm sure it sounded fantastical to her too. So like when she was on, one of the questions that was asked by her attorney when she went on News Nation was, why did you come back and stay at the same location of which these people ganged, did this to you? And she was like, that was the same question that I asked. I asked the exact same thing. And she basically said where was she gonna go? She didn't have any money, she didn't have any keys, she didn't have this, she didn't have that. And that's why she said, and I don't really know. Basically, she doesn't really have an explanation as to why she went back. But when you look at the complaint and it talks about how she was so weak and her body got weaker and weaker, but then you lay there, but then you're able to get up coherently, get a knife, knowing you need to protect yourself, put you a knife up your sleeve, go down, and then argue with Diddy about whether it was an essay or not, talk to his mama, run upstairs, run downstairs. All of this is supposed to be after you're incapacitated, because you got this oil that you're saying is lace, and you had this medication that you're saying he put down your throat that you don't know what it is. So I mean, she got an uphill battle. I would surmise if I were to guess. But again, all of these are allegations. He has not been found liable. This is basically a he said, she said contest right now. You said, why not go through the front door? She ran after Diddy with a knife. Okay, so that's what she said. I'm just reporting. Yeah, that's pretty much jackpot. She went to get a knife to escape, and then she decided to, because she was back there in the backyard and they was making jokes saying, according to her, they were making, man, you got enough drugs to basically put down a horse or whatever, like a tranquilizer type deal. And I think that amount that came from, because I believe Busby, when he did his, see, I'm listening to all these buzzwords in this complaint, because you got Christina Quorum, who is supposed to be the assistant. You're alleging that she was saying, I'm gonna sell you, or you don't mess her face up because we can sell her. You know that's an allegation that's basically in the indictment. Then you got the tranquilizer quote, which is something that I know Busby said in his situation. You know, Busby was talking about somebody had a tranquilizer, I believe, in his press conference. So some of this stuff, I feel like I heard it before. Like some of these lines or whatever, it just feels like I heard it before. But good luck. Elite Leo said the complaint is BS. I guess we'll see. We'll see what the court says. I'm starting to wonder if these suits aren't being funded by Diddy to flood the zone with so much absurdity that nothing is believed. Very interesting, Andrew. Is that but I don't know, because I know, for instance, with the attorney area, what I will say is she's the one that I told you filed against Chris Brown. She's filed against Trey Songz. She's been trying to kind of be that Gloria Allred with the women rights type thing. So I wouldn't believe that when it comes to her. And this is her complaint. So I don't know if that would be something that she would do. She does seem like she's trying to be that attorney for a woman's attorney, the victim's attorneys or whatnot, as one of her niches in her firm. But then the sassy naturalista said, how does she remember so many details after being drugged with drugs that cause amnesia? Great point. And we have to say that with a lot of people that file these complaints as well. So yeah. People think that Diddy's money is endless, and that's just not the case. He doesn't have enough money to pay everyone. He doesn't, and I'm sure he doesn't have liquid money either. He may have assets. When they tell you're a billionaire, it's based on your ownership. It could be all type of intangible type things as well. His intellectual properties is worth money, and it's all estimated and valued. That doesn't mean he has the money on hand. And I doubt he has insurance that's going to cover all of this. Most insurance does not cover these type of intentional torts. And if it did cover it, then they probably did that with Cassie and then dropped them as soon as they paid all that money, if that was the case. Wild Card said this is beginning to sound like the Pelican Brief movie plot. That was a very those facts are deserving of like a some type of a movie or something. It did sound, when I was reading it, it was like, what happens next? It's very detailed, very, very detailed. People's expressions, Diddy came in like he ready to party. Like it was very creative writing. Like if you're taking creative writing classes where you just don't miss out on the detail, this is like that. And you're doing synonyms and antonyms, and you're trying to paint the picture. So when you read it, you feel like you're there or you're in the thick of all of this. That's how it was written. So yeah. Yeah, these are happening at different locations. Cause and this one with the young, this is supposed to be the second complaint I read was a Marriott. The first one with the young lady. I want to know who Shane is. Shane, whoever you are, we need you to come. We need you to approach the bench because we need some information from you. Because yeah, Shane seems like he's on all these reports, is what she's alleging. She never put Diddy's name on it because she felt that was what was stopping people from investigating. And well, let me see if I get in. The passport life said, "What's going on here? I haven't been to a party in 40 years. I've asked Diddy to help with college about 15 years ago. Thank God he did not answer. Perhaps I would be asking for an envelope too." Listen, that's why they tell you to thank God for him protecting you from those things that you didn't know, the seen and the unseen. Those things you didn't know you needed to be protected from. That's a praise break right there. When Pam said we not gonna be here long, I just got up and started cleaning my kitchen because I knew we was. Don't do me like that, traveling Tootie, because my husband did the same thing. I was like, I'm just gonna go on for 30 minutes and I'm just gonna talk about this one document, and then I'm getting off. He was like, "You gonna be on for 30 minutes?" I was like, "Yeah." Here we are, hour and a half later. Okay, y'all got me. Y'all got me. I get carried away a little bit. That was a good one though. I'm guilty. I'm guilty. I don't even need a plea agreement. I'm just guilty of that. That is true. So but anyway, y'all, I'm about to get off of here though, for real in real life. And if we find out, let me double check this before I have to come right back here and see if there's any new information. Nope, it's nothing else filed. So that's it. You guys hit the like button on the way out. Subscribe to the channel. You know, all that good stuff that you guys are probably tired of hearing. You like, listen, lady, I did that already an hour ago. Why you keep asking me to do that? Well, for those of you that forgot, it's just a friendly reminder and prompting. But you guys have a fabulous day. And if they file that brief though today, we're gonna be right back on today. Otherwise, I'll see you guys later. Have a great day.